Assembly's on Thursday, and then everything should be complete. Who wants to do something that's in your case? No.
You would have overlooked it because I come to that door. Yes, I just did it. Yes, that's correct. All right, do I have any other lawyers here that are ready?
Not ready yet, Judge.
Okay.
A couple stopped in and stepped out, so as soon as they come back, we're ready to do a couple more.
I thought Stuckmore was 10, was 2.
It doesn't?
Ms. Keefer, is Mr. Teepan here?
You're covered.
I'm covering too.
Oh, you're covering for Mr. Teepan. Okay, thank you.
Scared for it.
Okay.
Yeah, I'm like, wait a minute. Surprise. So what's your name?
Andrew Hucklefinch.
This is what we need for kids.
That's why.
Good morning, Mr. Greenberg.
Good morning, sir.
Excellent. You're checking in for Mr. Taggart.
I received it right there. He's not here.
Okay, is she not coming today?
I haven't heard from her since before the last hearing.
Okay.
I sent her a notice.
It's set for 10, so I will be calling you at 10. She's not here at 10, and we're going to proceed.
I did reach out to her this morning, but that's everybody.
Okay. Well, she has about,
Generally.
she has about 42 minutes.
I used this.
Okay, so we have some other things.
Yeah.
But you don't have any else today, did you? You did? What'd you bring me?
Oh, we go.
We're going to somebody else's backyard.
But he's in here.
I will do my best, but you're the I will do my best.
So sure.
No, I hate. Let me take it. I'll take it out. I'll do my best. Just because it's you. Anybody else? I'm going to say that. Sure. That's
Just a little dot. That little dash on top of the dash.
This one?
Yep.
Yes, ma'am.
She was an artist, she is, she was apparently on her.
This is second one on the way.
That is gross. You could also tell me this really gross me out. You just did tons of
Small town newspaper.
Oh, right. It's texting. It's crazy. This guy filed this over to the. Here, you can have this back now. Thank you.
Call me.
Hi, ready? Ready on your things, Mr. Ewing? Want to do it first? Judge, do you want to go on the record or do you want to do sidewalk?
Whichever the next one.
Sidewalk?
We have two cases.
Good luck, Judge.
Good morning.
Mr. President,
Uh-huh.
you have to go there.
Yes.
But so I have to go to the judge Sanders' decision to consider.
Why was, he released from church?
These two years, what the. I guess he was doing here. And I guess he was and he also doesn't know he just he says he's okay, but he knows that because I'm not sure what kind of circumstances. Eventually, something around
Does he understand the whole CDC drug court?
I mean,
That we take my example, I had to put several people in drug court, only for them to go 6 months and then come get picked out and come back to you. And then I have to get the case resolved quickly, and then some of them even go into ILC. So I'm real leery back and forth from drug courts and back to the regular doctor.
Couldn't get drug treatment when normally through this avenue.
He can get drug treatment in home. So we can just leave this, doesn't, he goes to drug court, he's successful, it's dismissed,
depends on what,
or do we get the flu there?
yes, he does it at first, and then fine, I don't know what this,
He's an American.
yeah.
The felony.
Probably, because of the picture, well, let's see, you can see, and the judge first, a lot of that stuff, you can see, the judge standards, follows the rule, city of Ohio,
So what does that mean? So sometimes they
I guess-
discuss it, sometimes it's not.
Sometimes they say long, it's kind of like, yes, what they discuss.
I see. Well,
So maybe, I can let you know, just say, they want to ask the two weeks. There's another, it's back to the PG.
take them back. Does she do that? Does she typically take somebody back that she kicks out?
It's a case by case.
Oh, I see.
Sometimes she will, sometimes she won't. Because I guess she goes with the evening. She goes on the evening. What means that the not drug.
All right, well, I'll continue this for 30 days to see if you can do that.
She said 2 weeks.
Well, I don't know.
Okay.
2 weeks. 2 weeks. I mean, if
I obviously,
If-
no.
yeah, if it's a no, and if it's a yes, then you just get the entry of her signature and bring it to me and then I'll transfer it. All right. Ms. Howard, can you get 30 days on Cunningham for a field trial setting?
Yes, ma'am, how about September 13th?
No, that's fine.
Okay, that's good. September 13th at 9. All right.
I'm gonna send you that body camera anyway, so that it doesn't get lost.
All right, so what I would only do in this instance, since he's already kicked off, is if you bring me an entry with Judge Sanders' signature printed on, then I'll transfer. Other than that, short of that, I'm not transferring it and then she signs it.
Oh, no.
Okay. All right. What do you have?
Warrant's not.
Uh-huh.
Mr. Morgan, please not that he is a commute order for visual control violations. Preliminary discussions. Central Group, Mr. Gibson.
Okay,
Just gonna ask for.
short continue.
Sure.
All right. Ms. Howard, can we have 3 weeks on Mr. Moffitt?
August 31st?
That is.
August, that's good. At 9 a.m. Time waived.
I'm ready on the.
Thank you so
Thank you,
much.
Mr. Mayor, gentlemen.
Try.
Mr. Monday, do you want me to text this off?
I did already.
Oh. Better friend than me. And you're making us perfect. See, they're like a ladies' pretty girl.
You see, give me, those 2 days of good waiver. Mr. Mundy, are you ready?
I texted, Mrs. Oswald,
Okay.
she's a permanent with her.
Okay.
Mr. Brown just signed us.
Okay, all right, thank you.
Transfer to jury waiver.
Sure, thank you. Thank you.
Seventeen.
I'm calling her. There's shenanigans.
Mr. Mitchell?
Yes.
Mr. Mitchell?
Mr. Pitt is here, but we know Mr. Perkins has the code pending.
Okay. Small justice, they could jail. Ms. Commissioner, Mr. Washington is calling in, so you can just give me my number.
Sure, which case is that?
Mr. Washington is calling.
Oh, okay, let me.
Mr. Washington. All right, we are ready. The matter of State of Ohio versus Donald Stable-Moller. Case number B2201880. Mr. Stable-Moller is present in the courtroom with his attorney, attorney Andrew Hopple-Finch, covering for Mr. Craig Teaton. This matter is set for sentencing today. Is that all that accurate, Mr. Hopple-Finch?
Yes, Your Honor.
All right. And you were aware, Mr. Stable-Moller, that you're all right with Mr. Hopple-Finch covering?
Yes, ma'am.
All right. Mr. Stable-Moller, you entered a guilty plea to count one, the single count indictment of forgery, a felony of the 5th degree, on July 7, 2022. A PSI was waived, but a victim impact statement was ordered. I did receive a copy of the victim impact statement. Has counsel had a chance to see it?
Yes, Your Honor. It's my understanding that they reached out and get anything back.
Well, they didn't get anything back on the Pro Tech Coding Company, but they did get information back from Fifth Third Bank on the altered check.
She requested restitution of what I have, Your Honor.
Okay, thank you. All right. What would you like to say on behalf of Mr. Stable-Moller?
Your Honor, Mr. Stable-Moller, he is already sentenced out of Claremont County from Judge Dad on 2 other counts. His projected out date is March 16th, 2024. He is looking forward to taking advantage of any educational classes that are available through the Waiver Correctional Facility. He has been interested in CDO classes that they offer, and that this is an F5. We would ask the court, if the court is inclined to impose any sort of sentence, to do it concurrently with those that sentence out of Claremont County.
All right, thank you very much. State?
Judge, the check that was cashed was $6,715. Understanding that they're being reimbursed, the victims, we just ask for restitution and also to stay away from Fifth Third Bank.
All right. Mr. Stegemuller, anything you'd like to say? Okay. Well, this is a felony of the fifth degree, and so there's a presumption of community control, which I was inclined to do. I did not realize he was serving another sentence elsewhere.
Yes, sir.
Can I see Council Steiner real quick?
The check was $6,715.
The court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions that the court determines accomplish these purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I've recently calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact not only on the victim, but on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I've also considered the seriousness and recidivism factors as set forth in revised code 2929.12. Accordingly, I hereby sentence you, Mr. Stegemuller, to 1 year community control with costs, no fine. You will be ordered to pay restitution in the amount of $6,715 to Fifth Third Bank. I will issue a stay-away order from Fifth Third Bank and ProTech Coding Company. I will advise you now that should you violate the terms of community control, I will sentence you to prison for 12 months. Do you understand? All right. Now, this community control sentence will be in abeyance, be held until you finish your time with Claremont County. And then you'll be on community control to Hamilton County so that you can make restitution for this offense. Do you understand? All right. Do you have any questions, sir?
Your Honor, we could find an indigency for Mr. Stegemuller.
Let's see, I think he's been in for 77 days, is that right? Okay. All right, I'll cost remit.
Thank you, Your Honor.
And you have a right to appeal your conviction and sentence should you choose to do so, Mr. Stegemuller. You must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed at no cost to you to help you. Do you understand? All right, I wish you well.
Yes. I just texted, you should agree to do.
I'm ready for you on. He's the waiver, he's the one that. He's the one else, so we're not.
And Mr. Brown.
This one. Could we approach on Maderas?
Sure.
Good morning, how are you?
Yes, what's going on this side? Underwood, looks like September first, we have final pre-trial, and the end of September 26th, we have a jury trial.
That's correct. So all discovery has been exchanged.
Okay.
Still reviewing that and trying to determine if we can work something out. So when when we kind of get to that point in time, I'll reach out to Ms. Keefner. And we'll, if need be, hopefully, we can get it resolved. We'll do it at the final trial.
Sure. Is Mr. Maderas here?
No, it was a status today.
All right.
So I asked to waive his presence.
Okay, that's fine. So it sounds like all of you guys keep doing what you're doing, but just continue this to the final pre-trial conference, which is September 1st. Is that all right?
That's great.
Time is very,
Yes, sure.
okay. Is anything you want to add?
No, Judge, just when you're ready to talk about our resolution of the law, I'll get it in the meantime, I'll pick up and touch it down, so see what is it.
All right.
Sounds
Perfect, sounds good, thank you.
Thank you, Judge.
Have a good day.
You too.
This hour, I believe their schedule as already is on my conference.
Oh, hi, how are you? Oh, good. Maybe approach our applicant. Yes.
All right, set your trial.
Yes, Judge, this is the one we did our Zoom last week about, we have a quick alert.
Oh, excellent, okay.
Unfortunately, I received a phone call from a special needs parent, he is in the hallway. He's out there. He has an incredibly gruesome injury on his leg. He needs to go to the hospital.
Oh, right now?
Yeah. I think that would be nice. I would have prepared everything else brain, but I didn't know until I was already there.
Oh,
So, I don't know if the court would consider letting us step this over a week, a plea.
well, it's said, okay, yeah, I have the documents. Is the documents executed?
So the plea, no, I have not executed yet, but I can.
No, yeah, I want the documents executed before I, because today's set for jury trial.
I'm happy to do that.
Okay, yeah, let's do that.
Okay, I'll let you know. I'm gonna get the, victims out of it.
So we're gonna need to continue, interview for a plea to next week. So, is a hospital. He's here, he's in the hospital.
all is such a deal, but he would be able to hold to that. Yeah. Sure. Oh, hi. Give me 1 second. I'll be right there. I think that's, yeah. So, so if you a single person, no, it's always always want to hear somebody else. I can send you out for today, sir. Pitch you some right, we the other gentleman's table too, on the other side.
We're waiting on your client and Ms. Oswald.
That's correct, Judge.
Okay. Oh, you did, okay, last week. So I'm going to be,
Oh, my God.
This,
You did not respond to my text message.
just Howard is trying to reach her as well. We'll get it. She should be here any moment. Good morning. Madam Prosecutor, do you know, Miss Howard, do you know, Miss Oswald, ETA? Let her know that Mr. Brown is in the courtroom. Yes. Yes, it is, for sure. I just had to.
No worries. Right, we make her respond. Sorry. You're welcome.
Mr. Mundy, can I ask that this, I know that Ms. Oswald's in here, but Ms. Keeper can come up for a minute, I just kind of want a preview of what we're doing today.
Which I can switch her. Switch her numbers.
Oh, you can't hear.
He's the leader's charge in count 17 and 19 for sort of force. And then he's going to lead count 26 for his alcohol and drinking. And there's a recommended he has 430 days to 26.
All my numbers are here.
I can dismiss 7 counts. It's not signed by Ms. Oswald, but if you want to look over the plea form.
I'll just wait till she gets here, thank you, though.
Good morning, Your Honor.
Good morning.
The judge here?
matter of State of Ohio versus Randall Brown, case number B2102878B. Mr. Brown is present in the courtroom with his attorney, Mr. Bernard Mundy, and Ms. Allison Oswald for the State of Ohio. This matter was set today for a status report, but it's my understanding that Mr. Brown has decided to resolve this matter. Is that accurate, Mr. Mundy?
Yes, Your Honor.
All right. Is that accurate, Mr. Brown? All right. Are you the Randall Brown named in this indictment? How old are you, Mr. Brown?
21 years of age.
21? How far did you go in school?
I graduated.
All right, so you're able to read and write the English language well. And are you a U.S. citizen? Have you ever served in the military? All right. I think I better keep my mask on just to be a model person. All right. All right. Mr. Brown, I have in my hand a single-page document that is entitled Waiver of Trial by Jury. And at the bottom, there are signatures right here. I recognize Mr. Mundy's signature here and his bar number. Is this your signature here, sir, where it says defendant? This is an acknowledgement by you that you have a constitutional right to have a trial. But when you sign this form, you're saying, I understand that, but I am waiving, I'm giving up my right to a trial. Is that your understanding of what you were doing when you signed this form? Did you sign this form after consulting with your attorney about your constitutional right to a trial? Do you have any questions about this form? Do you have any questions about your constitutional right to a trial? I also have in my hand, Mr. Brown, a 3-page document entitled Entry Withdrawing Plea of Not Guilty and Entering the Plea of Guilty. And on the top here it says Agreed Sentence Plea. On the 3rd page, there are signatures. And I recognize Ms. Oswald, the prosecutor's signature here in blue, right above Mr. Mundy's signature and his bar number. But right up here, sir, where it says signature of defendant, is that your signature? All right, thank you very much. Madam Prosecutor, would you please put on the record the party's expectation regarding this plea?
Your Honor, the state understands that the defendant is prepared to plead guilty as charged to counts 17 and counts 19 of the indictment. The state is going to amend count 26 from the felony of the 1st degree to a felony of the 2nd degree, trafficking in a fentanyl-related compound, and that we will be guilty. We are going to tender an agreed recommendation to the Ohio Department of Corrections for 4 years on all of those 3 counts. And the state will be dismissing counts 18, 20, 21, 22, 23, 24, and 25 per plea.
All right. Mr. Mundy, is that accurate?
That's correct, Judge.
All right. Mr. Brown, is that your understanding as well and your expectation? All right. Sir, are you under the influence of any medications, any alcohol or drugs today? Do you now, have you ever suffered with or even been diagnosed with any type of mental health difficulties? Are you presently under any type of probation or community controlled supervision in this or any other state? Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today? Has anyone promised you anything at all other than the dismissal of certain counts and the reduction of 1 count? Has anyone promised you anything if you plead guilty? Are you making this plea of your own free will? All right. Now, Mr. Brown, I just heard the prosecutor say that it is the expectation that you would be pleading guilty as charged to counts 17 and 19, both felonies of the 4th degree, and that the state is going to ask on count 26 that the offense level is reduced from a felony of the 1st degree to a felony of the 2nd degree, but it still will be trafficking in a fentanyl-related compound. Is that what you talked with Mr. Mundy about today? Did you talk to him fully about this before today's hearing?
Judge, can I just also clarify something? I want to make sure the plea form also reflects that the major drug offender specifications associated with count 21 and count 22, we are dismissing those as well.
All right.
Is that on the dismissal line?
It is not, I apologize,
Yeah.
I wanted to put it on there, just put the counts.
Okay,
So we wouldn't want that, Mr. Brown.
all right. So, let me just, summarize again. Is it your understanding and what you talked with your attorney about today and before this morning, is that you would enter a guilty plea as charged to count 17 and 19, both felonies in the fourth degree? Is that, all right. And then you would enter a guilty plea to count 26 as reduced from a felony in the first degree to a felony in the second degree. Is that what you talked with Mr. Monday about? And that all other counts and all other charges would be dismissed at the state's request. Is that your understanding? Is that what you talked with Mr. Monday about today? All right. Have you had an opportunity, Mr. Brown, to review this 3-page plea form with your attorney? Did he answer all your questions about it? Do you understand what it says? All right. Do you understand that this is a agreement between you and the state to recommend to the court that you serve a sentence of 4 years in the Ohio Department of Corrections? Do you understand? Now, do you understand that while you and the state have presented this sentencing recommendation, that I don't have to accept it? Now, I'm not indicating in any way that I won't, but I'm not obligated to accept the recommendation. Do you understand? Knowing that I'm not obligated to accept the recommendation, do you still wish to enter a guilty plea as outlined by the state? All right. Mr. Brown, do you feel like you've had enough time to consult with your attorney about your entire case before this morning? Has your lawyer answered all of your questions to your satisfaction? Have you had an opportunity to review with your attorney the evidence that the state has against you?
Yes.
Madam Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any, to your knowledge?
Judge, I have been the only prosecutor to handle this file. I do believe between Mr. Brown's 2 attorneys that I have handed over everything. The body worn camera movement is designated for counsel only, but it has all been turned over to the defendant, except for pending with the lab right now is a DNA analysis between Randolph Wilson and the baggies of drugs that were confiscated from his possession. That's the only thing outstanding, but that wouldn't be related to Mr. Brown.
All right. Mr. Monday, is all that accurate?
It is, Judge.
And you acknowledge you see the same?
I do acknowledge receipt the same, I received the file from Ms. Blazer, along with the zip drive, and all the information that Ms. Hall also was writing. I reviewed it and discussed it robustly with Mr. Brown.
All right, thank you very much. Mr. Brown, are you satisfied with your attorney, Mr. Monday?
Yes.
Now, sir, do you understand the charges in count 17, 19, and the reduced charge in count 26? Count 17 is trafficking of cocaine. Do you understand that charge? Count 19 is trafficking in a fentanyl-related compound. It's a felony of the 4th degree. Do you understand that charge? And finally, count 26 is being reduced to trafficking in a fentanyl-related compound felony of the 2nd degree. Do you understand that charge? You understand that if you plead guilty to these offenses, you are making a complete admission that you committed the allegations contained in those 3 counts of the indictment. Do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately? Now, counts 17 and 19 being felonies of the 4th degree, Mr. Brown, you understand that you are facing between 6 and 18 months in prison and up to a maximum fine of $5,000 in each count? Do you understand that as count 26 being reduced to a felony of the 2nd degree, that you are facing a potential sentencing range between 2 years and 8 years in the Ohio Department of Corrections, with a maximum fine of $15,000. You understand that if I sentence you to prison, upon your release from prison, you could be on post-release control on counts 17 and 19 for up to 2 years. Do you understand that? But you shall be on post-release control for count 26, which is a mandatory sentence, for between minimum of 18 months to up to 3 years. Do you understand? And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. You understand? So for example, with this agreed sentence of 4 years, and if you serve that time, you come out, and if you were to violate post-release control, you could be sent back to the institution for up to 2 years. You understand? All right. Are you on post-release control right now? Well, do you understand that if you are convicted of a new felony offense while on post-release control, that in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term, or whatever time remains of your post-release control time, or whichever is greater. Do you understand? You have any questions so far? All right. With regard to the felonies of the 4th degree, count 17 and 19, community control is a possibility. Do you understand that I could place you on community control for up to 5 years instead of sending you to prison on counts 17 and 19? You understand? When you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons? Do you understand that you have a right to confront witnesses here in open court and have them cross-examined by your lawyer? Do you understand that you have a right to have witnesses subpoenaed to come to court and testify for you? Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt? Do you understand that you cannot be forced to testify against yourself at trial? Do you understand each of these rights as I've explained to you? Do you have any questions whatsoever about your constitutional rights? Do you have any questions about anything we discussed this morning? All right. Do you understand that if you plead guilty, you are waiving all of these important constitutional rights, and you're giving them up? Do you understand? Knowing everything the court has told you and discussed with you this morning, do you still wish to enter a guilty plea as charged to count 17 and 19, and plead guilty to count 26 as reduced to a felony in the 2nd degree? Is there anything further from counsel before I accept the plea?
No, Your Honor.
All right, and your statement of facts.
Count 17, Randall Brown, on or about April 30th, 2021, Hamilton County, State of Ohio, knowingly sold or offered to sell a Schedule II controlled substance, cocaine, in an amount that was less than 5 grams, and the offense was committed in the vicinity of a school or in the vicinity of a juvenile. Count 19, Randall Brown, on April 16th, 2021, Hamilton County, State of Ohio, knowingly sold or offered to sell a Schedule II controlled substance, fentanyl, in an amount that was less than 1 gram, and the offense was committed in the vicinity of a school or in the vicinity of a juvenile. In count 26, understanding the defendant waives all defects, reissuance and rearrangement of the amended charge of trafficking in a fentanyl-related compound is a felony of the 2nd degree. Randall Brown, on or about June 4th, 2021, Hamilton County, State of Ohio, prepared for shipment, shipped, transported, delivered, prepared for distribution, or distributed, a Schedule II controlled substance, fentanyl, when the defendant knew or had reasonable cause to believe that the controlled substance was intended for sale or resale by the defendant or another person in the amended F2 amount in the vicinity of a school or in the vicinity of a juvenile.
All right, anything on the facts?
No, Your Honor.
All right. Mr. Brown, did you hear what the prosecutor said you did? Is it all true?
Yes.
What is your plea to count 17, trafficking in cocaine, a felony of the 4th degree?
Yes.
What is your plea to count 19, trafficking in a fentanyl-related compound, a felony of the 4th degree?
Yes.
And finally, what is your plea to count 26, trafficking in a fentanyl-related compound as reduced to a felony of the 2nd degree?
Yes.
Let the record reflect that Mr. Randall Brown was present in court with his attorney, Mr. Bernard Mundy, and that Mr. Brown was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Randall Brown understands the nature of the charges, the effect of the pleas, as well as the maximum penalties which can be imposed. Finding them to be voluntary, the court accepts the guilty pleas and finds Mr. Randall Brown guilty as to count 17, trafficking in cocaine, a felony of the 4th degree, in violation of revised code 2925.03 subsection A1. The court finds Mr. Brown's guilty plea acceptable and voluntary in count 19, accepts the plea, and finds Randall Brown guilty as to count 19, trafficking in a fentanyl-related compound, a felony of the 4th degree in violation of revised code 2925.03 subsection A1. And finally, the court finds that Mr. Brown's guilty plea is voluntary as to count 26 and accepts that plea and finds Randall Brown guilty as to count 26, trafficking in a fentanyl-related compound as reduced to a felony of the 2nd degree in violation of revised code 2925.03 subsection A2. Counts 18, 20, 21, 22, 23, 24, and 25, as well as all MDO specifications, which is major drug offender specifications, as set forth in counts 21 and 22, are all dismissed at the state's request. Is there any reason why sentence should not be entered today, Mr. Mundy?
No, Your Honor.
All right, what would you like to say on behalf of Mr. Brown?
Judge, it is our hope that the court will impose the recommended 4 years in the Ohio Department of Corrections, give Mr. Brown 430 days. He has been in custody pending resolution of this matter. And I would just say to the court that Mr. Brown is one of the sharpest clients on my docket. If he were to apply himself in different ways, I think he could be successful.
All right, thank you very much. State?
Judge, this was part of a long-term investigation out of the District 4 Violent Crime Squad. As you can gather, counts 17 and 19 were controlled buys, and count 26 was the defendant fled the house where they were keeping all of the contraband, and when he realized the police were onto them, there was a pursuit involved. He had changed clothes, gotten multiple rides, but we appreciate him accepting responsibility for his involvement in this organization and ask that you follow the agreed 4-year sentence, which was approved by the investigating officer, Detective Jennings.
All right, thank you very much. Mr. Brown, is there anything you'd like to say before I pass sentence?
No.
All right. Mr. Brown, have you ever been to prison?
No.
This will be your first time,
Yes.
and hopefully your last. Is this Mr. Brown's first felony offense?
Yes, Your Honor, as an adult.
First felony conviction?
Yes, Your Honor.
Does Mr. Brown have a juvenile record?
I believe so, Judge.
All right. Felony convictions or just truancy and unruly?
I believe they were more significant than that. Is that correct, Mr. Brown?
Mr. Brown, can you tell me about it?
I had went to a rehabilitation center, possession.
Okay. How old were you?
I was 17.
Oh, that was a felony offense.
I think so.
How long were you at the
I
license?
just went to a rehabilitation center for 4.5 months. Rehab.
Oh, I see. So you didn't, that's not UIS, right?
No,
Okay, for rehabilitation.
it was
Like a treatment center.
Butler County Juvenile Rehabilitation Center.
Oh, okay. Yeah. Okay. All right, Nancy, counsel for this one. All right. The court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions that the court determines accomplish the purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I have reasonably, and the joint recommendation of the parties. I've reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society. And I considered the seriousness and recidivism factors set forth in 2929.12. I've also considered that this sentence is consistent with sentences imposed for similar crimes committed by similar offenders. Accordingly, Mr. Brown, I hereby sentence you to a term of 12 months in the Ohio Department of Corrections on count 17. And 12 months on count 19. And a total term of 4 years on count 26. Count 17 and 19 they'll all run concurrent with one another, all right, for a total term of 4 years in the Ohio Department of Corrections. So 12 months on 17, 12 months on 19, 4 years on 26, all to run concurrently with one another. Do you have a waiver, affidavit?
An affidavit is yes, Your Honor.
All right, yeah, I have that.
Yeah.
Has he already executed it?
May I approach, Your Honor?
Yes. Mr. Brown, you have been in the Justice Center for a total of 430 days. I also have been handed an affidavit of agency. So the first thing I'm gonna do is credit you 430 days, jail time credit, plus any days of conveyance that it takes to get to the institution, all of that will be credited. Because you've been in the Justice Center for quite some time, I will accept your affidavit of agency and remit fines and costs.
Thank you, Your Honor.
And, just for the record, you did waive the PSI.
Still waiting, Your Honor.
All right, thank you. Mr. Brown, you have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. Do you understand? All right, I wish you well. Mr. Hitch, Mr. Perkins?
Good morning, Your Honor. Brian Perkins on behalf of Mr. Lewis.
Mr. Josh Hicks, on behalf of Ms. Reardon.
All right, thank you very much. These are the matters of State of Ohio versus Jacoba Lewis and Emmanuel Razine, case numbers D22013116A and B. These matters are on for a status report, and Ms. Alison Oswald from the State of Ohio. Counsel, you received discovery.
Yeah, we did. We received body camera. I believe it was on Thursday. I've not had an opportunity to go through it all yet, but we have received it as of last Thursday.
All right, and Mr. Hitch?
That's the same report from you.
All right, so it looks like we have some dates here. Jury trial date, August 29th. What, are we on track for that?
On behalf of Mr. Lewis, Your Honor, this case, that trial date was actually set before I even came on the case. It was set by his prior counsel. That day, I have another jury trial scheduled in another courtroom. We had, I believe the last court date we brought up the possibility of this date getting continued, and we're going to address it at this point. So my position is I would ask if we could vacate that date because of a prior commitment I have on that very same date.
Is Mr. Lewis here?
He is not, Your Honor.
Well, that's a problem.
That is a problem, Your Honor. I find it odd because I have been speaking with him regularly on the phone. I spoke to him as recently as Friday. We had an extensive conversation, and he was aware of this date, and I asked him to be here. I don't understand why. I tried to this morning. I texted him as well as tried to call him, and I'm not able to get through to him.
Oh, all right, well, I thought I made it clear last time, and it sounds like you made good effort, but I made it clear last time that his presence was required today. It's not.
You did, Your Honor.
He's not here. Okay, what about your client, Mr. Razine?
Similar situation in terms of presence. I've been in contact with him on the phone. I do not know why he's not here today.
Oh, okay. Well, I'm not asking for their presence to be here. I'm requiring their presence to be here. So, State, what do you have to say?
Judge, we would, note that you did on the record indicate that they must be here. You did that on July 7th, so we would ask for a KPS.
Then you, Mr. Perkins, said you talked to your client yesterday?
Friday.
Friday. And Mr. Hitch?
Mine was earlier in the week, but it happened recently.
And they didn't give you any indication that they wouldn't be here?
No, we discussed the need, made it clear that he was gonna be here. I even asked him to get here at 8:30 so we could talk beforehand. Like I say, I'm at a loss as to why he's not here. He's been easy to get in contact with by phone, and there's no doubt he made it clear that he was required to be here.
Similar, with the exception of some of the specifics about being here at 8:30, I had good phone contact with him, but we discussed this court date.
All right, well, I think that what I'm gonna do is I'm gonna leave the trials on. And I'm going to, I know you need to continue this, Mr. Perkins, because you have a conflict. But Ms. Howard, is there any dates before the trial that we can bring this in for?
18.
18. Can you do the 18th, gentlemen?
Judge.
Yes, Your Honor.
All right, excellent. Continue for the 18th. 9 a.m. Clients are to be here at 9 a.m. Not 9:01, 9 a.m. At 9:01, if they're not here, I'm issuing warrants. And then the trials will be vacated. All right?
Understood.
So if you can just relate to them, which I'm sure you have, that I'm not asking them to be here. I'm telling them they're to be here at 9:01 on the 18th, a warrant was issued for their arrest. All right?
Thank you very much.
Thank you.
I'm sorry.
Yes,
You want-
All right. Mr. Greenberg,
Good morning, Your Honor.
good morning. You want to talk sidebar?
Yeah.
I see his text here.
Yes.
Okay, what we doing?
I've asked the prosecutor to consider it.
I am probably not in the best position to,
Need to wait for Krista.
talk about that.
Okay, wait for Krista.
I'll text him.
Right, what, she's in my room,
You can do that.
but we, Mr. Washington is on
Yes,
this.
I'll do that. And what about Mr. Henry? All right, a few more minutes, Mr. Ma'am? What we're gonna do this time? Henry?
So it's my understanding that the court wanted to do for me today.
I don't, well, please wait for a second. I,
what is this case?
this is, Henry. We have to get him here. He's here, and then he's to the hospital, but this is a situation where he's been here for some time right now.
Yeah, I don't think you can stand for an entire plea. The court would allow it to sit.
Absolutely.
And then I wasn't sure if the court was going to set this up for PSI or anything like that.
That's if you want to do with PSI. I don't mean that the victim is here, it's time to get it done today. If not, I'll do it.
I think there was going to be a restitution note. I'm not sure if they were going to have
Okay.
people before.
Well, then why don't we, set it over, victim's here, so I'll let her talk. And then, we'll set it over for, PSI. All right, so you're gonna go get this.
She's on her way back, but if we can just go to the back, all right.
So we're gonna call, Henry, as soon as this speaker is back.
Well, do you want to, we have first, yes.
Otherwise, yeah, giving somebody else and actually. Yeah. Appreciate that so much. First, yeah.
Yes, so. All right, let's this is Alice's all, I didn't wait for you.
All right, where's he going?
Mr. Evans,
Mr. Evans.
I think he was like,
that was fine, okay.
he was double checking if I was okay with something.
All right, so where did Miss, Where did Mr. Henry, Mr. Henry's case done? But Mr. Greenberg, what are you doing on Mr. Greenberg's case? Here, okay. This lady, I don't know what she's saying. So it is. You ready?
Yes.
Okay, this is our chair for Mr. Henry, who is clean. Mr. Henry, do you have a mask? Okay. This is the matter of State of Ohio versus Patrick Henry, case number B 22-00943. Mr. Henry is present in the courtroom with his attorney, Ms. Kelly Leggett, and this matter is set for jury trial today, but it's my understanding the parties have reached agreement, and I've been submitted and handed plea documents, including a waiver of trial by jury. Is that accurate, Ms. Leggett?
Yes, sir.
All right, is that your understanding today of how you want to proceed, Mr. Henry? All right. I'm allowing you to sit, do this proceeding today, Mr. Henry, because it's my understanding you have a leg injury. All right.
We appreciate that greatly, thank you.
Are you the Patrick Henry named in this indictment?
Yes,
Mr. Henry, how old are you?
ma'am.
52?
Yes, ma'am.
All right. And sir, how far did you go in school?
I got a grade at GED.
So you're able to read and write the English language well?
Yes, ma'am.
Sir, are you a U.S. citizen?
Yes, ma'am.
Have you ever served in the military?
No, ma'am.
Mr. Henry, I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize your attorney's signature here. Sir, is this your signature here where it says defendant?
Yes, ma'am.
This is an acknowledgement by you that you understand that you have a constitutional right to have a trial. But when you sign this form, you're indicating, I understand that, but I'm giving it up. I'm waiving my constitutional right to a trial. Is that your understanding of what you were doing when you signed this form?
Yes, ma'am.
Did you sign this form after speaking with Ms. Leggett about your constitutional right to a trial?
Yes, ma'am.
Do you have any questions about this form?
No, ma'am.
Do you have any questions about your constitutional right to a trial?
No.
I also have in my hand a 3-page document entitled Entry, Withdrawing Plea of Not Guilty, and Entering a Plea of Guilty. On the 3rd page, there are signatures. I recognize the prosecutor's signature in this pretty blue here, and then your attorney's signature here. Is this your signature here above where it says signature of defendant?
Yes, ma'am.
All right, can I have it quiet in the courtroom? If we talk to your client, please go out in the lobby. Mr. Henry has a right to have the court hear everything he's saying. Madam Prosecutor, would you please put on the record the party's expectation regarding the plea?
We reduced charge to a felony of the 5th degree. The victims are here today, and we'll be looking to go forward with that today.
All right, thank you very much. Is that accurate, Ms. Leggett?
Yes, sir.
That is our understanding. Is that your understanding, Mr. Henry?
Yes, ma'am.
All right. Sir, are you under the influence of any medications, alcohol, or drugs today?
Prescribed medication,
All right. And what conditions do you take prescribed medications for?
Judge, it's for the injury. My understanding is he has to go to the hospital once this week. They prescribed him pain medication. He's not doing well, so he's planning to go back.
I see. All right. And that's it's the medication that you were prescribed for your leg injury?
Yes.
All right. Do you now, or have you ever suffered with or even been diagnosed with any type of mental health difficulties?
Very much schizophrenia and bipolar.
All right. And were you prescribed any medications to manage those diagnoses?
No, ma'am.
All right. So you take no medication for your schizophrenia or your bipolar? All right. Are you getting any type of treatment or management through UCB?
GCB.
All right, so you do go to UCB? All right, thank you. Are you presently under any type of probation or community control supervision in this or any other state?
No, ma'am.
Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today?
No, ma'am.
Has anyone promised you anything at all if you enter into this guilty plea today?
No, ma'am.
Are you making this plea of your own free will?
Yes, ma'am.
Now, the state has indicated, sir, that it is the expectation that you would be entering a guilty plea to the single count of the indictment, the charge of receiving stolen property, but you'd be reduced from a felony of 4th degree to a felony of 5th degree. Is that what you talked with Ms. Leggett about before this hearing?
Yes, ma'am.
Did you have an opportunity to read and review this plea form with your attorney?
Yes, ma'am, I did.
Did she answer all of your questions about it?
Yes, ma'am.
Do you have any questions right now?
No.
Do you understand what the plea form says?
Yes.
Mr. Henry, do you feel like you've had enough time to consult with Ms. Leggett about your entire case before this hearing today?
Yes, ma'am.
Has she answered all of your questions to your satisfaction?
Yes, ma'am.
Have you had an opportunity to review all the evidence that the state has against you?
Yes, ma'am.
Madam Prosecutor, would you please put on the record whether or not the state is providing all discovery evidence, including any Brady material, if any, to the defense to your knowledge?
Yeah.
Ms. Leggett, do you acknowledge you see the same?
Yes.
Mr. Henry, are you satisfied with your attorney, Ms. Leggett?
Yes, ma'am.
Now, do you understand the charge against you as reduced of receiving stolen property of felony of the 5th degree?
Yes, ma'am.
Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in this count of the indictment?
Yes, ma'am.
Do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
Yes, ma'am.
Now, this being a felony of the 5th degree, do you understand that you are facing up to 12 months in prison, up to a maximum fine of $2,500? Do you understand?
Yes, ma'am.
Do you understand that if I sentence you to prison upon your release from prison, you could be on post-release control for up to 2 years?
Yes.
And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand?
Yes, ma'am.
Are you on post-release control right now?
No, ma'am.
Well, do you understand that if you are on post-release control and you're convicted of a new felony offense while on post-release control, in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains in your post-release control time, or whichever is greater. You understand?
Yes, ma'am.
Since this is a felony of the 5th degree, community control is a possibility. That's probation. Do you understand that I could place you on community control or probation for up to 5 years instead of sending you to prison?
Yes, ma'am.
Do you understand that if you are placed on a probation or community control sentence, you will have to abide by all probationary conditions as established by this court?
Yes, ma'am.
And if I place you on community control and you violate the conditions of community control, you'll be brought back before me for a more restrictive sanction, which could include, among a host of other things, the most severe penalty, which is imprisonment up to 12 months that I previously discussed with you. Do you understand?
Yes, ma'am.
Also, if I impose court costs and you fail to pay those court costs, I could order you to do community service. Do you understand that?
Yes, ma'am.
Do you have any questions so far?
No, ma'am.
Mr. Henry, when you plead guilty, you give up some very important constitutional rights, and I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons?
Yes, ma'am.
Do you understand that you have a right to confront witnesses here in open court and have them cross-examined by your lawyer?
Yes, ma'am.
Do you understand that you have a right to have witnesses subpoenaed to come to court and testify for you?
Yes, ma'am.
Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt?
Yes, ma'am.
And finally, do you understand that at trial, you cannot be forced to testify against yourself?
Yes, ma'am.
Do you understand each of these rights as I explained them?
Yes, ma'am.
Do you have any questions whatsoever about your constitutional rights?
No.
Do you have any questions whatsoever about any of the things we discussed this morning?
No, ma'am.
Do you understand that if you plead guilty, you are waiving or giving up all of these important constitutional rights?
Yes, ma'am.
Knowing everything the court has discussed with you today, Mr. Henry, do you still wish to enter a guilty plea to the reduced charge of receiving stolen property of felony of the 5th degree?
Yes, ma'am.
Is there anything further from counsel before I accept the plea? All right. May I hear the statement of facts?
Yes, Judge, this is any and unnecessary waivers that Patrick Henry, on or about the 22nd day of June 2021, Hamilton County, State of Ohio, do not receive, retain, or dispose of the property belonging to Robert Wigglesman. Now we are having reasonable cause to believe that that property was obtained through the commission of a theft offense.
Mr. Henry, did you hear what the prosecutor said you did?
Yes, ma'am. I did.
Is it true?
Yes, ma'am.
What is your plea to count one, receiving stolen property, a felony of the 5th degree?
Guilty.
Let the record reflect that Mr. Patrick Henry was present in court with his attorney, Ms. Kelly Legler, and that Mr. Henry was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Henry understands the nature of the charge, the effect of the plea, as well as the maximum penalty which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Patrick Henry guilty as to count one, receiving stolen property reduced to a felony of the 5th degree in violation of Revised Code 2913.51 subsection A. Is there any reason why sentence should not be entered today?
So do you think we had discussed a week and a half statement?
All right, so you're gonna ask for a PSI?
Yes.
All right, and I will also order a victim impact statement, but I understand that we can make you here today.
Just there are two victims here. There's the gentleman whose vehicle it was, and there's also a gentleman who had plates that he had put into a garbage vehicle count on the car. He is also present because the subpoenas were part of the trial. But I do know Mr. Wimbledon would like to address the court today.
Okay, all right, well, sir, would you mind stepping up? This lady, if you wouldn't mind taking that microphone off of there, just taking the microphone, yeah, there you go, thank you, that's even better. All right, sir, your name for the record?
Robert Wimbledon,
All right, how do you spell your last name, sir?
Wibbelson.
Thank you very much. Sir, what would you like to say?
What I'd like to say is that, again, my vehicle was taken off of the lot, and the hardships that I endured with trying to find the vehicle was very difficult. And I'm out of, would ask for restitution. I'm probably out about $3,500 to $4,000 based off of what my insurance company paid me versus funding the truck that I have to have.
Was your vehicle taken from your parking driveway?
It was taken from my place of employment.
I see.
The vehicle was left overnight and was taken from there.
Do you know Mr. Henry?
No, sir, I do not.
All right. And so you're gonna be asking for restitution in the amount of about between $3,000 and $4,000? I see. All right. Can you tell the court how, and Mr. Henry, how this impacted your life?
Okay, it's impacted it very greatly. Prior to this, thought I was very safe. Again, I'm always looking around anymore on making sure that I park my car in, a place that has a camera. Again, just always keeping my doors locked. Where I always felt safe. I no longer felt safe in my employment, leaving my vehicle at the shop. I worked for a repair shop. And I used to keep it out on the lot because my job was to drive over the vehicles home a lot of times. Instead of leaving it out on the lot, I would have to put it back inside the garage. After I got it, replaced. They're usually very trusting anymore. Especially where I park my car, people walking up and down the street. Now every time I look up, it's just, what, are they doing something? I don't like living that way. I like living away to where I can trust other people. And that is going to take away from me.
I thank you, sir, very much for your statement and being candid about how this has affected you. Thank you so much for being here today. I am going to order a pre-sentence investigation report. Our probation department will do an investigation. They will contact you because I would like to get your statement again in writing and also whatever documentation you have for the amount that you're claiming for restitution.
Okay,
Thank you, sir, so very much for being here today.
very well.
All right, so Ms. Howard, can we get a date for sentencing?
How about September 13th?
Sure, September 13th work for both of you?
Yes, September 13th.
All right, September 13th, we'll continue this matter for sentencing. September 13th, 2022 at 9 a.m. Now, Mr. Henry, you will have to go to the probation department today for your precinct's investigation. You have to cooperate fully with them, answer all their questions, and they will provide a written report to the court. I will provide that to the council, and we'll go forward with sentencing on September 13th. Now, I understand that you are actually headed to the hospital, so, for your leg, I understand. So, we will make that known to probation. So I'm gonna give you until either the end of today, depending on how long you're at the hospital, or tomorrow to, appear at probation for your interview, okay?
We appreciate it.
All right, thank you very much. That's how we have to call the probation and let them know that I am allowed to, give this next time. Miss out. All right. Anything else, this, Keithner?
I believe there's gonna be at least another plea here in a moment, as soon as Mr. Evans comes back.
Miss Pat. And,
It's on the other side.
that's it.
Thank you, sir. You want to take that?
Yes.
Okay, thank you.
So I just have a Pat and Bill Bonnie.
Yes.
Okay, and you're gonna take
I'll
over?
cover that for you, Judge.
Okay, thank you.
Sorry.
She's going to try, right?
Yeah.
All right.
Judge Mark's room.
Oh, okay. We might kick her head in there. Later. Oh, you just started jury selection, right?
We're doing a motion, and then we're gonna start doing this one.
Maybe tomorrow. Okay. All right, I need Mr. That is Mr. Greenberg. Officer, you've been here all morning. What case are you here on?
No, got it. However.
Okay, yeah, let's get this evidence in here. The hard thing is the attorneys are expected in courtrooms all over the building at the same time.
I understand.
So they come in and the attorney's been here, but in the middle of something else I was doing, so he left and then got, so I'm sorry.
I understand the process.
Ms. Chess, are you all short staffed?
Yeah,
Because I know when you come over here, it's like they must be
I know.
really short.
and then I'm trying to prepare, I'm leaving for vacation, so I'm trying to prepare,
2 trials that have.
Oh, my goodness.
Yeah, but you know, David Hickenlooper's wife.
Yeah,
So
yeah.
we're short, yeah.
Oh, gotcha, okay, he's still out.
Yeah, he won't be back after Labor Days, because I think his kids are gonna be home until the end of the month.
It makes sense.
Yeah.
It makes sense. That's a significant loss.
Yeah.
And I think they were married, what, like 20-something,
Yeah.
30 years?
Yeah, their kids, the youngest is like a senior in college.
Yeah.
The other 2 girls are grown, but it's,
Yeah,
I think it's gonna hit up hard now, even.
yeah, I need to give him a card or something.
Yeah, it's, he's a good guy.
He is.
Yeah.
I worked with him a little bit, even out court.
Yeah,
He's a great guy, I just feel so bad for him.
Yeah, it's terrible. I think we're all like, everybody's, I think every team is short.
Yeah.
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 We're trying to still make sure everybody's covered. So,
But you know, I went to, I don't know, I think it was a fast food restaurant or something. Anyway, they were saying how they were short-staffed.
yeah.
And it's pretty much everywhere.
Is
And
it?
I'm like, where did everybody go?
I don't
After
know.
COVID, like, where did people just go?
I don't know, like the airlines, like.
Everything, everybody's
Everybody's
short staffed.
canceled because they said they don't have enough employees. So my sister was going, I think to Turks and Caicos, she said they were delayed in Atlanta because they didn't have enough employees. It's crazy. And then my brother called me, he goes, oh my God, our refrigerator is on the fritz. We went to Home Depot and buy another one, but they said they couldn't deliver because there's no employees. What? I said, where did everybody go?
I don't, yeah, it's really baffling.
Yeah.
Since COVID, it's like, people just dropped out of the workforce.
Right.
And where are they?
I know, it's like, and
Where are they living?
they're all short too, like nurses, like.
Yes, everybody.
Like teachers.
Bus drivers, I mean, everybody is short.
Well, my neighbor who's a nurse, and she retired, she was like close to, she's not 65, but she's early 60s, she's like, she said after COVID affected her, she's like, you know, I was tired, and she was like, I couldn't take it anymore, seeing all the patients dying, she's like,
Yeah.
That's just, she's like, no, I'm trying to move forward. Good for you.
Yeah, I can see the healthcare industry, right, but it's just like, not restaurants.
Right.
And airlines, and like, where is everyone?
And I guess restaurants are closing, right?
Yes.
Yeah, so it's sad.
Yeah.
And the restaurants, I don't go to OTR because if I would want to work, like, I would be up there, so, like, I was like, Senate still open up, like, no, they went to Blue Ash, or this restaurant closed, what happened?
I don't really fully understand it.
Right.
I'm just like, well, the population is the same. Where is everybody? Why is the workforce?
People need jobs, people need jobs.
I don't know. I think I'm missing something, but I just can't conceptualize where everyone is.
Right. I don't know, my sister and my son had gone, they went to Sicily for vacation, and they were stuck in Boston, literally for 3 days.
Oh.
Because they said the airlines didn't have, they had technical issues, not enough employees, so they were stuck. And all they paid for was the hotel near the airport every day. And they're like, and we'll give you a voucher for $12 a day for food.
Oh my
She's like, well, what about tours they paid for?
Oh my God.
Yeah, she had tours paid, she had rental cars, she had hotels, she said, I don't know if she got money back.
Wow.
Yeah, and I don't even know if she paid for insurance. You know, you get those, it's terrible.
Officer, are you all short at all?
We were actually just now coming up to full staff.
So you were short?
Yes, we were very short. I've been with Parks almost a year and a half, and I'm out of our department of 26 to 28 for full staff. I'm now 11 in seniority.
Oh, wow.
So just to get a grasp of how short we were.
Yeah.
Part of that was due to COVID. Part of that was also due to the fact that our wages were in the lower 20th percentile, or the lower end 20th.
I see.
So
Yeah.
we took steps that have allowed us to get back up to staffing, but at a disadvantage, the majority of our staffing were on.
Wow. Wow. All right, Mr. Evans. You ready?
Yes, Your Honor.
All right. What are we doing today?
Your Honor, the state has offered us, a plea. We just, my client wants a little time to think of it before he does it today.
Okay. All right, so this is a matter of State of Ohio versus Hassan Delagi. Delagi. All right. Case number B 2201-327. Mr. Delagi is present in court with his attorney, Mr. Evans, and Ms. Jocelyn Chess for the state of Ohio. Now, we have a jury trial set at the end of next month and a final pretrial conference on September 1st. And there's been an offer, and you just want more time.
Just a little time to think it over, Your Honor.
All right, well, what I'm gonna do is I'm gonna keep it, set at September 1st for the final pretrial conference. If your client is ready to resolve this case before that date, have the plea forms filled out, and then just let Ms. Howard know, and we'll get you on the docket.
Okay.
Okay, but if you don't get that done before the 1st, we'll see you on the 1st, September 1st, okay?
Thank you, Your
All
Honor.
right, thank you very much. I'll motion Mr. Delagi is present, time related to the trial date.
Yes, Your Honor.
All right, we'll see you then. Thank you. This is a small finance Yes, I had told the prosecutor, he just called me and I said, keep it on as scheduled. That's it. People would it will be paid more than their jobs. But they're not the only ones. No, they're not. I don't know what happened. Mr. Greenberg, you ready? Okay.
Okay, that sounds good. I have it here, if you don't want to show up, I have it again. Okay, yes.
All right.
Okay, thanks, everybody speaking.
Did we have, status on
Have a good day, bro.
Thank you, have a good day, be safe.
Oh, you have it. I didn't see that, okay.
Just see the prices on the bus. Because of the storms and fires, because of. Oh, it's crazy. You can't find it with the. Oh, that's upsetting. The small kind of big. That's crazy. It is. And some people are just working. You know, because how it was small.
We should have yes. I probably mentioned this.
Okay.
All right. This is the matter of State of Ohio versus Tara Peck, case number B22011052. Ms. Peck is present in the courtroom with her attorney, Mr. Matthew Greenberg, and Ms. Jocelyn Chess for the State of Ohio. This matter was set for a jury trial today, but it's my understanding the parties have reached agreement. Is that accurate, Mr. Greenberg?
Yes, it is.
All right, is that your understanding too, Ms. Peck?
It is, Your Honor.
All right, thank you. Are you the Tara Peck named in this indictment?
Yes, I am.
Ma'am, how old are you?
41.
I'm a
41.
41, okay. And how far did you go in school, Ms. Peck?
I did like EMS after school, so I guess trade, vocational, past high school.
Past high school?
Yeah,
All right. So so you're able to read and write the English language well?
absolutely.
And ma'am, are you a U.S. citizen?
I am.
Have you ever served in the military?
I have not.
All right. Ms. Peck, I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize Mr. Greenberg's signature here, his bar number. And is this your signature here, ma'am, where it says defendant?
Sloppy, yes, it is.
All right. All right. Ma'am, this is an acknowledgement by you that you understand you have a constitutional right to have a trial. But when you sign this form, you're indicating, I understand that I'm waiving, I'm giving up my right to a trial. Is that your understanding of what you were doing when you signed this form?
Yes, it is.
Did you sign this form after speaking with Mr. Greenberg about your constitutional right to a trial?
I did.
Do you have any questions about this form?
No, ma'am.
Do you have any questions about your constitutional right to a trial?
No, ma'am.
I also have in my hand a 2-page document entitled Entering Withdrawing Plea of Not Guilty and Entering a Plea of Guilty, Reduction to a Misdemeanor. And on the second page, there are signatures. I recognize the prosecutor's signature here, Ms. Chess, your attorney's signature and his bar number here, and then up here, Ms. Peck, is that your signature?
Yes, it is.
All right, thank you. Madam Prosecutor, would you please put on the record the parties' expectation regarding the plea?
Yes, Judge, the state is requesting that count one, which was found in the plea, be reduced to a misdemeanor, the first degree, it's being amended to attempted aggravated possession of drugs, and really is open plea to sentencing.
All right, is that accurate, Mr. Greenberg?
Yes, it is.
Is that your expectation and your desire today, how to proceed, Ms. Peck?
Yes, Your Honor.
All right. Ma'am, are you under the influence of any medications, alcohol, or drugs today?
I take cardiac medications, that's about it. Cardiac meds, that's it.
All right. And does that cardiac medication interfere at all with your ability to think clearly?
No, not usually.
All right, thank you. Do you now, or have you ever suffered with or even been diagnosed with any type of mental health difficulties?
Just depression.
All right, and do you manage that diagnosis with medication?
I'm currently trying to get in back with my psychiatrist.
Okay, so you don't have any medication for it? Are you trying to get back in with your?
Yeah, I'm trying to get back in with the same group that I was with, but there's a little bit of a wait, so.
All right, all right. Are you presently under any type of probation or community control supervision in this or any other state?
I'm not, no.
Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today?
No, Your Honor.
Has anyone promised you anything at all if you enter into this plea of guilty today?
No, Your Honor.
Are you making this plea of your own free will?
I am.
Now, ma'am, the state has indicated that they're going to ask the court, they're asking the court to reduce and amend this from a aggravated possession of drugs of felony of the 5th degree to an attempt, a misdemeanor of the 1st degree. Is that your understanding? Is that what you talked with Mr. Greenberg about before today's hearing?
Yes, it is.
Do you have any questions at all about this 2-page plea form?
No, I do not.
Did you go over it with your attorney?
He did, yes.
Do you understand what it says?
I do.
Do you have any questions about it?
No, ma'am.
Ma'am, do you feel like you've had enough time to consult with Mr. Greenberg before this hearing today about your entire case?
I do.
Has your lawyer answered all of your questions to your satisfaction?
Yes, above and beyond.
Have you had an opportunity to review and or discuss any of the evidence or the evidence the state has against you?
Yeah, we discussed it.
Madam Prosecutor, would you please just put on the record whether or not the state has provided all discovery, including any Brady material, if any, to your knowledge?
To our knowledge, Judge, we have.
All right. Mr. Greenberg, you acknowledge you see the same?
Yes, so acknowledged.
Ms. Peck, are you satisfied with your attorney, Mr. Greenberg?
Absolutely.
Now, ma'am, do you understand the charge against you as amended and reduced to an attempt, aggravated possession of drugs, a misdemeanor in the first degree?
I do.
Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in the reduced and amended charge of attempt of felony of the fifth degree, misdemeanor in the first degree?
I do.
Do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
I do.
Now, this being a misdemeanor of the first degree, do you understand that you are facing up to 180 days in jail and up to a maximum fine of $1,000?
Yes.
Also, since this is a misdemeanor of the first degree, do you understand that community control or probation is a possibility?
Yes.
And that I could place you on probation for up to 5 years instead of sending you to jail?
Sure.
Do you understand that if you are placed on probation or community control sentence, you'll have to abide by all probationary conditions as established by this court?
Yes.
And if I were to place you on probation and you violate the terms of probation or community control, you'll be brought back before me for a more restrictive sanction, which could include a host of things. But the most severe penalty could be up to 180 days imposed for jail. Do you understand?
I do.
Also, ma'am, if I impose court costs and you fail to pay those court costs, I could order you to do community service. Do you understand?
I do.
Do you have any questions at this time?
Could you, if you were gonna impose fines, could I, request that you do community service?
I'm sorry?
Can I request to be placed on community service in lieu of fines?
Yes, you can.
Okay.
I'll take that as your request.
Yes.
Okay. All right, any other questions? All right. Ma'am, when you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a right to have a trial either to the court or to a jury of 12 persons?
Yes.
Do you understand that you have a right to confront witnesses here in open court and have them cross-examined by your lawyer?
Yes.
Do you understand that you have a right to have witnesses subpoenaed to come to court and testify on your behalf?
I do.
Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond reasonable doubt?
Yes.
And finally, do you understand that at trial, you cannot be forced to testify against yourself?
Yes.
Do you understand that you took these rights as I've explained them?
I do.
Do you have any questions whatsoever about your constitutional rights?
There you go.
Do you have any questions, ma'am, whatsoever about anything we discussed this morning?
I don't think so.
Do you understand that if you plead guilty, you are waiving or giving up all of these important constitutional rights?
I do.
Knowing everything the court has discussed with you today, Ms. Peck, do you still wish to enter a guilty plea to the reduced and amended charge of attempted aggravated possession of drugs, a misdemeanor in the first degree?
Yes.
Counsel, is there anything further before I accept the plea?
Nothing further.
All right, may I hear a statement of facts?
Yes, Judge, on about March 3rd, year 2022, in Hamilton County, State of Ohio, in the vicinity of 918 Dalton Avenue, near Red Squirrel Restaurant, the defendant, Tara Beck, did knowingly attempt to use a Schedule II controlled substance, 2 with methamphetamine in the mouth, less than bulk amount. Essentially, Judge, the defendant was sleeping under an umbrella next to the Red Squirrel Restaurant. She was in possession of a paper filled with methamphetamine and glass pipes, which tested positive for methamphetamine residue. Tested positive under the Hamilton County Crime Lab report, CL number 22-01524.
Ma'am, did you hear what the prosecutor said you did?
I did, yes.
Is all of that true?
Yes.
All right. What is your plea to count one as amended and reduced to attempted aggravated possession of drugs, a misdemeanor of the first degree?
Guilty.
Let the record reflect that Ms. Tara Peck was present for her attorney, Mr. Greenberg, and that Ms. Peck was informed of all of her constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Ms. Tara Peck understands the nature of the charge, the effect of the plea, as well as the maximum penalty which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Ms. Tara Peck guilty as to count one as reduced and amended to attempted aggravated possession of drugs, a misdemeanor of the first degree in violation of revised code 2923.02. Is there any reason why sentence should not be entered today?
No reason, we're prepared to proceed today, since,
Are you waiting PSI?
yes, it has to work the way it presents this.
All right, what would you like to say on behalf of Ms. Peck, Mr. Greenberg?
Your Honor, as I understand, Ms. Peck has no prior felony conviction. She's taking responsibility in this case. If my count is correct, it looks like she's 13 days of pregnancy in this case.
How many days do you have?
I show 13.
All right.
Ms. Peck, as she's indicated before already, is under doctor's care for advanced cardiac failure. And she told me that she has not, her health report, that she has not been using illegal drugs since this offense. She understands that the drug could kill her given her heart condition. And she's also indicated that she's reaching out to restart psychiatric care. She lived, at the time of this offense, in our age, we heard the state of this Peck was experiencing homelessness. But before that time, and since that time, she has obtained residence at a residence where her apartment building manager provides housing in exchange for her work, additionally to the housing she's in.
And where is this?
It's on Baltimore Avenue.
Okay.
It's like Fairmont, South Fairmont.
Okay.
So she is working. She told me today now she's applied for disability benefits based on both mental health and your cardiac. So all of that saying, her phone actually was broken since last week. That's why she didn't respond to my attempts to reach out to her. She wasn't with the one time to look for. She did show up. And she told me that she will have money to get her phone working today. And she just gave it. So taking all those factors into consideration, I asked the court to go to fair sale.
All right, thank you very much. State?
Nothing further.
All right, Ms. Peck, is there anything you'd like to say before I pass sentence? All right. So you're stable now with your housing
Yes,
and then you're working?
yeah, it was kind of like, he was just kind of helping me until I could get my disability. I had a third interview. I'm locked out of my online account to apply online, so I had to have somebody call from Social Security to do the application over the phone. So he knows my abilities are limited with my heart, so I was just kind of helping fill in temporarily until I can get my disability, even though it's probably going to be denied at first, but just to be some kind of asset or value to him until I can have that steady income, from the disability coming in. But yeah.
Do you have an attorney helping you for your disability?
Well, I had everything from my brother trying to get on the disability attorney training, but yeah, I do have somebody who's representing me. They had to have me file first before they represent me, so yeah, I see.
All right. Well, the court has considered the overriding purposes of felony sentencing, and I know this is being reduced to a misdemeanor. And so I have considered the need for incapacity. And I I am going hereby sentence you to 25 days in the Hamilton County Justice Center with credit for 25 days served. That's the amount we have, Mr. Greenberg, that she served in our system, so that's what I'm gonna give her credit for. I'm gonna, remit the costs and fines at this time, given her situation. So I appreciate your request for community service, you don't have to, do that either. I'm, remitting the costs, and, that's it. I'm not placing you on probation. I am going to, just close your case out, and I wish you well. And it's my hope to never see you in this courtroom again, and I hope that your, health improves.
Thank you.
You have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. Do you understand?
Thank you.
All right, I wish you well, ma'am.
Thank you so much for your work.
Thank you for covering.
Thank you.
See you, Mr. Greenberg.
Have a good day. Thank you, you too.
Thank you.
When I asked him who he was here, what case he was here for, he said he was this guy.
Oh, okay. Good, maybe he's helping now.
Well,
Can you turn this off, please, before you do that?
Yeah.
She's reading. That's excellent. Isn't that awesome? Yes, it's really good. I'm happy about it. You're welcome, sir.
I hope you're okay.
Thank you so much. We took the ball for real.
Oh, my God.
Oh, that's all.
Melody,